Hello and welcome to the regular business meeting for the District of Squamish for Tuesday, March 17th. Holland Squallen, Quistoktamak, Tla Squamish Okmeo. As always, we're gathered to do our work today on the traditional unceded territory of the Squamish Nation. Please be advised this council meeting is being live streamed, recorded, and will be available to the public to view on the District of Squamish website following the meeting. If you have concerns, please notify the corporate officer present at the meeting. In this case, that would be Ms. Vaughn Boudreau. Can I have someone move adoption of the agenda, please? Moved by Councillor French, second by Councillor Stoner. All in favor? Any opposed? Motion carries. Thank you. So our first order of business is item 3.1, the BC Epilepsy Society. And I believe we'll be receiving a presentation remotely. Oh, there you are. Hello, thank you for joining us.
Hello. Good evening, Council. I'm the administrative coordinator with the BC Epilepsy Society. Unfortunately, our executive director, Deidre, was unable to speak today with illness, so I'm still grateful for the opportunity to be here to represent our organization. And I'd just like to thank you guys again for the opportunity to speak and for the support of epilepsy awareness in our community. We truly appreciate the leadership and the commitment to help build a more informed and supportive community in Squamish. Epilepsy is one of the most common neurological conditions affecting approximately 1 in 100 people. This means that here in Squamish, many individuals and family are living with epilepsy and contributing to the strength and diversity of this community every day. With greater awareness and understanding, we're hoping we can create an environment where people living with epilepsy feel supported and empowered, and simple actions like learning about epilepsy and recognizing the Epilepsy Awareness Day on March 26th will help encourage more open conversations, making a meaningful and lasting impact. Your support helps us to build that community where people feel confident and safe. We're grateful for the partnership and the role to help us bring awareness. Thank you again for your time and support. If anyone has any questions, please let me know.
Thank you very much for the presentation. Council, do we have any questions for our guests? We also have the proclamation request as it appears in the agenda. If there's no questions, I'd entertain a motion. Are you moving the recommendation, Councillor Pettingill? A second by Councillor French. Would you like to speak to it, Councillor Pettingill?
Just to say thank you for coming and presenting and reminding us about this. I think it's always good to keep these things top of mind, and it's a simple and small gesture we can do to help with that. Thank you.
Thank you. Any other comments on this? Happy to support this proclamation. I do think it's, as Councillor Pettingill said, it's really important that we, even through a small gesture like this, ensure that these types of things, and particularly epilepsy here, receives the recognition that it deserves. There are people living in our community and that have epilepsy, and we may not, unless we are nearby when they experience an episode, it's unlikely that we would necessarily be aware of that. So this is an opportunity for us to show our support. I'm happy to do so. So thank you very much. And with that, I'll call the question. All in favor? Motion carries unanimously. Thank you so much. Enjoy the rest of your evening.
Thank you for your time.
Thank you. So next we have the unscheduled public attendance. This is if anyone has a matter they'd like to have considered by council prior to our next meeting. This will be an opportunity to put that forward. No takers this evening, so we'll move on. We do not have any public hearings, so we're on to the consent agenda. Would anyone like to pull anything that is in the consent agenda? Or move the consent agenda is the alternative. Councillor Stoner?
I'm going to pull items D1 and 2, please.
Okay. So we'll deal with those at the appropriate time. Is there Anyone that would like to remove the remainder of the consent agenda? There's not much left for those that aren't reading the moving. Councillor French, second by Councillor Hamilton. All in favor? Motion carries. And we'll deal with those at the appropriate time later in the in our agenda. So now we have consideration of first, second, and third reading for the District of Squamish indemnification bylaw number 3224/2026. And we have our corporate officer or director of corporate administration to present to us. Okay, I'm happy to take a quick timeout or a medium length timeout if that's what's needed. It's coming. Okay. So just to buy some time without taking a timeout, I'm going to propose we move forward to, we have a couple adoptions on the agenda. So that's 7B1 and 2. And as is our common practice, we don't have a presentation on these. These are ready to be adopted. All the T's have been crossed and I's have been dotted. So so the first one is District of Squamish zoning bylaw number 2200/2011 amendment bylaw. And this is regarding local and liquor primary commercial. Moved by Councillor French, second by Councillor Hamilton. All in favor? Motion carries. Thank you. And the next is District of Squamish zoning bylaw number 2200/2011 amendment bylaw regarding indoor recreation. Moved by Councillor Stoner, second by Councillor Hamilton. All in favor? Any opposed? Motion carries. I hope that we may have bought at least some time. We'll come back to, there we go. Look at that. The floor is yours when you're ready.
Good evening, Council. My name is Melissa Bomblito. I'm the Director of Corporate Administration. Today, I am presenting on District of Squamish Indemnification Bylaw number 3224/2026. There were changes made to the bylaw this morning, including the correction of 2 typos, including a reference to a specific section in the Local Government Act, and replacing guilty with convicted in section 5.1G of the bylaw to align more closely with the Local Government Act language. The bylaw has been replaced online and the current copy is in blue in front of Council this evening. The bylaw in front of Council this evening, if it is adopted at a future meeting, will repeal the current indemnification bylaw, which was adopted in 1998, and be replaced with the bylaw before Council right now. The purpose of an indemnification bylaw is to establish parameters for when the district will pay for and defend municipal officials, which is defined in the bylaw, from legal claims that may arise out of the performance of their duties or functions on behalf of the district. This could include paying for legal defense costs, settlements or judgments, or certain penalties related to official duties. It does not allow for the district to pay for a fine that results from a conviction where the official was at fault or had intent. And examples of this may be fraud or knowingly violating legislation. The bylaw will establish clear expectations as to when the district must be notified that a legal matter has arisen, which can be found in section 4.2 of the bylaw. The bylaw also sets limits on when municipal officials will not be indemnified under section 5 of the bylaw, which include if there is a conviction where there is a finding of negligence or willful misconduct. Next section is legislative alignment. The content of the bylaw has been drafted to align with language in the Local Government Act, specifically sections 738 and 740. This includes the definition of indemnity, the definition of municipal official, limits on indemnification for the following: when a finding has been made related to dishonesty, gross negligence, malicious or willful misconduct has been made against a municipal official, and this is section 5.1A, and limits on indemnification when a municipal official has been convicted of an offense that is not a strict or absolute liability offense. This is section 5.1G in the bylaw and in the definition of indemnity. There's also alignment with the community charter, including in the limits of indemnification section, including breach of confidentiality under section 117, and this is section 5.1E of the bylaw, and disqualification from holding office under section 111, section 1.5F of the bylaw. And that includes my presentation this evening. Thank you.
Thank you very much for the presentation. Council, questions on this? Go ahead, Councillor Pettingill.
So how does this work with insurance companies who would, I believe, typically be the ultimate payers? Were there a judgment against someone who is, I presume, covered by this? Like, does the fact that we have this bylaw then obligate the insurance companies to provide that to anyone, you know, or an organization they're insuring, or is it still ultimately up to an insurance company how things proceed or what happens? Or can you speak to that a bit?
Through the mayor. So the district's municipal insurance company is the Municipal Insurance Association of BC, and they handle very specific claims for us. And when a claim is passed to MIA BC, they handle every aspect of that claim. So prior to accepting a claim, they make a determination whether it fits within the scope of our municipal coverage. If a situation was to arise where there may be a conflict with our bylaw, I'm sure they would be flagging that in advance of accepting the claim or representing the district. But I have not seen a specific example like the one you've referenced.
Thank you. Yeah, you have a follow-up?
Yeah, just sort of big picture wine touching, because I had the impression that as elected officials, we in particular had very little protection against even our own mistakes. This implies there's something more. Am I correct though in thinking that this doesn't really, I guess maybe can you just speak a little more to sort of where there is some protection available if something like it's clear if you do something willfully wrong, you're not protected. But if you're sort of doing things with the best of intentions on, what are still the limitations in this?
Through the mayor, I actually brought a couple of examples that I can speak to, and hopefully that will help frame it a little bit, because to be honest, the language in the legislation isn't always clear and it is confusing, and I had to do a fair bit of research to wrap my head around this. So if you'll be patient with me, I'll find a few examples here and read them out. The first example is a municipal official is convicted of knowingly falsifying records. So in this situation, the municipality cannot pay the fine. So if they were convicted and there was a fine issued, the municipality could not pay the fine. However, the council and the district does have discretion to pay some of the legal fees that may be associated in the determination of whether there was a conviction. Does that make some clarity? Okay, I'll go on to the next one. A councillor is fined under an environmental statute for an inadvertent regulatory breach despite acting responsibly. So there's another fine issued. In this case, there wasn't intent, so the municipality may pay the fine. Does that provide some clarity? Is it more confusing?
Like any good example, it may have triggered a few questions. So I'll go back to Councillor Pettingill.
Yeah, that one is a little confusing in that we have no individual ability to do an environmental action or whatever, direct one. So the word a councillor like is implicit, and this is actually the council and the majority vote, and it's the group that's protected, or is there some case where an individual is somehow, which seems like an impossible situation?
You could replace councillor with municipal official as defined by the bylaw.
But you're right. No individual councillor has a specific authority to take an individual action. So that would likely be the councillors that would likely be a multiple. I share your assessment with that. I was curious. I thank you for the examples. Those were yeah. Well, I know it is a challenging topic. I think it's just got a lot of what ifs to it. But I was wondering, in your presentation, it spoke to how it relates to community charter and legislation broadly. Where does the code of conduct sit in this? Like, I understand there's these, if there's a fine paid or a guilty or someone, in other jurisdictions, but was there a lens do we rely on those mechanisms for this, or does the code of conduct bump into it? Feels like that there's some overlap potentially, or how are we thinking about that, or can you orient me on that?
That's a good question. The indemnification bylaw is specifically if there's a legal claim against the district. So it's moved past the point where council in the district is dealing with a breach of conduct in-house, and it's moved into the legal sphere. So there is a fairly clear line between them, I would say.
Okay, thank you. That's helpful. Councillor Hamilton, yeah, go ahead.
Yeah, thanks very much. It's interesting that this bylaw has an interesting combination of council. The municipal officer includes council and employees of the municipality. And in terms of municipal employees, I see the logic for in part 3, the determination of payment of the indemnification amounts is determined by the chief administrative officer, the CAO, and the CAO being the head of the district. That makes sense in terms of the municipal officers. Does that make sense as well in terms of council? Are there other instances where the CAO has determination over council? When I think of the code of conduct bylaw, for example, council regulates council's, within that bylaw, council makes decisions. So I guess the question is, within other indemnification bylaws, is it common practice to have the CAO be a deciding, determining body on damages, awards, fines, penalties, and what reasonable costs will be paid for council?
Many of the other bylaws that we looked at when we were doing the research for this left that more open-ended. It ended as out-of-pocket costs, and some included the word reasonable. However, we didn't find any that specified a specific individual that would determine that. I will say, though, that we do have in the code of conduct bylaw, the CAO is the person that makes determinations about legal fees. If council needs to seek legal advice, it needs to go through the CAO. So we do have a little bit of a precedent there for that.
Okay. So what role does council play, if any, in determining whether council pursues or determines the level of indemnification that another councillor will be awarded? And awarded isn't the right word here, but what determining that reasonable level of cost, because at some point in time, somebody might get into a legal dispute and more money might need to go down that road. Does council play any role in that, or does that sit purely with the CAO?
Ca- If there is a legal claim that fits the parameters of the bylaw, if it is adopted, all the costs associated with that within reason would be covered because of the indemnification bylaw. So there isn't a threshold for when a legal claim needs to come to council for approval. I will say that if a legal claim doesn't fit the parameters of this bylaw, council has the discretion through the Local Government Act to direct that the legal claim is indemnified through council resolution.
Okay, thanks. I didn't realize that overarching piece of the Local Government Act. That's good to know. And yeah, my question, my point here is that discussion of what's reasonable and the determination of what is reasonable when a CAO, and this is not about our CAO, this is about power dynamics that get set up within councils and between the CAO, because the CAO can be either they can be put in a position where they are undermined by their council, and a CAO can undermine their council. That power dynamic can happen. And I'm reflecting here on whether this can contribute to that power dynamic in a potential sticky situation. But I don't think I have a better solution. And with the coverage of the Local Government Act that the council can step in and indemnify, I'm comfortable with the CAO being in this role here.
Would you like to comment on that, Ms. Glenday? Or sure, yeah. And just before we do that, we'll take it. There's been an ask for a quick timeout. I just in that section where it does say reasonable, I've always challenged. I know the language is there to provide some flexibility, and I just, but for all the reasons, I just wondered about the use of reasonable, because it does imply that everyone involved in it is that. So I'm just curious on if that's the best language for that. Although I understand why you'd want to put some reasonable limits on it. It's just hard to see it framed that way. So I'll wait for a reply till after this, but maybe I'll just flush out council, see if there's any other questions, just to make sure that we don't require another timeout on this matter. Go ahead, Councillor Pettingill.
Yeah, just sort of thinking of, I guess my understanding of conflict of interest is it's on us individually to decide and declare if we have a conflict. If we're unsure, it's on us to individually seek and pay for legal counsel to get that advice if we feel we're unsure. And whether we do or not, if we proceed in good faith and believing we're doing the right thing, but then it turns out we were actually offside, I had previously understood we would bear all the consequences individually of that. When I see this makes it seems like, you could sort of, well, I'm doing the best I can. I don't have money to have a lawyer, and I'll be indemnified at the end of the day if it doesn't work out. I don't think that's what this is trying to say, but that's what it seems to say. I'm looking for a way to understand why that case would be excluded from indemnification if you were acting in the best, with the best of intents, but it went south. Why would this, like, I don't, in the exclusions, it's not clear, or the limits, why that would not be covered.
Sorry, I'm not following the question. Could you provide the specific section or?
Well, I guess sort of say, there's an issue comes up. I decided to vote on it or do whatever. I thought I didn't have a conflict of interest, so I was proceeding what I thought was correctly. Turns out at the end of the day, someone, some court or whatever body decides I was wrong. There's some liability coming to me. I had thought I was stuck with that liability before today. Hearing the discussion, like when I look at the limits, this seems to say I would be covered. I would be indemnified in that case, but I don't think that's what this is saying. So I'm trying to understand, why is that case
Could you point to
outside of this?
Sorry, could you just point to the section that is that just sort of a general takeaway,
Yeah,
or
when
is
I'm
there a
looking at
specific section?
The limits on indemnification, there's nothing that says a counselor found offside on conflict of interest is not or does not qualify for indemnification. There's nothing along that sense. So I'm trying to understand why. Again, it's my understanding this case would not be covered by this, but I don't.
Okay, so we have a question around conflict of interest. We can put this in the after timeout. I don't know if that, or do you have a reply for how that fits, or would you like to group that with the timeout matters?
Group that with the timeout matters, and I'll have a crafted answer.
Okay, no, that's fine. And then I've got Councillor Stoner, and then we'll go to the staff timeout. We'll come back for another pass at this. Councillor Stoner, go ahead.
Yeah, thanks through the chair. I think I wanted to add some reflections on the word reasonable, which I appreciate is not defined and is really difficult to define, especially in this context. I think from a process and a procedure perspective, I think reasonable is often defined when you go out and seek like quotes for a legal cost, for example. And so I think adding some discretion there by using the word reasonable, I think is fine. I think in our procurement processes, we have ways to guardrail against what is reasonable. And I just think like taking out that word makes this bylaw really challenging to me, and trying to define it, I think, is near impossible. So I think there's other components of our process and our system that help guardrail the definition of reasonable.
Okay, thank you for that. And the last one of the other pieces that I have is just I do want to ask a question around the in section 5.2F is it says the provisions of this bylaw shall not apply to a motion of censure by the District of Squamish Council. So I'm just curious on how that interplays here. And I was expecting that as part of the answer from the code of conduct piece, maybe. So because censure is something that could flow from the code of conduct. So that's sort of where one of the things I was trying to get at with that question, but I'll leave that till after the timeout. Anything else before we go? Councillor Hamilton, go ahead.
Maybe just confirming. So I read through the LGA, and I think, Ms. Von Bluto, the section you were referring to was section 742A2, the municipal official's ability. If you could just confirm that on the timeout, and then we'll be on the same page.
That's 5.3 in the bylaw. We're going to grant the timeout, and then we'll address that because there's an easy answer for that one. So I feel like 5 minutes is the minimum for this. Would you like 10? 10? Let's take 10. We'll take a 10-minute break, and we'll reconvene at 6:42. All right, welcome back. We're back from a quick timeout for our staff. So I will go to CAO Glendale.
Thank you. Through the mayor, I will answer the question about the CAO being the determiner of the reasonable costs in Section 3. It's a great question. The purpose of that is financial control. And so the suggestion is to prevent it being a one-on-one with CAO and a council is to include or amend this bylaw or first 3 readings with the amendment to include and CFO and Chief Financial Officer. And then that way there's a financial control with a second signature or the second person vetting the costs that then get approved by MIEBC or not. So that is a solution for that. And that's the answer for that one. And I will, through the chair, pass it back to Ms. Von Blitto for the other answers.
Okay, so just on that one, does anyone have questions about that response? And thank you for a suggestion that addresses the concern. I'll just go to Councillor Hamilton. I think it was your question that sort of took us on this path.
Yeah, thanks. I think my concern was in many ways addressed by the clearer understanding of section 5.3. But I do think that adding a signature here or adding a partner in the determination, I think makes the whole bylaw stronger and makes our policies and procedures stronger. So yeah, I would certainly, I'll make a motion to add that if needed.
Okay, we'll deal with that when we get to there. Thank you for that. Anyone else on this particular piece? Councillor Pettingill?
So does this imply that as part of our budget, that somewhere there's a legal envelope there going forward, we might be a bit more explicit of like, this is the bucket we have for the CFO and CAO to possibly address these things for the coming year. And so council sort of approves an envelope annually and then sort of within that envelope would apply this bylaw?
Yeah, whoever would like to speak to, I guess, how we allocate legal into our budgeting.
Corporate administration has a general legal bucket that we set aside annually to cover all legal costs that are associated with the district, or most of the legal claims that are associated with the district. And at the moment, we've never had an issue with overruns from that budget.
And any expenditure, even under this, would need to be inside of the budgeted amount, just to state further that point. Any other questions on this before we go back for the answer on the second question, which I'm forgetting what it was at this point? Oh, yeah, go ahead, Councillor Sonner.
Can I just seek some clarity on the proposed amendment and how that would intersect with our general procurement policies? And so like there's a threshold, like I don't want to make this an overly cumbersome process. And we already require multiple signatures on larger expenses. So I'm just curious if this just feels like a redundancy to an existing parallel process that would be highlighted or initiated anyways out of this.
The current, I'm trying to think of the bylaw. Is it the delegation bylaw that refers to spending authority indicates that all general managers have a certain threshold, which includes the CFO, after which the CAO has discretion up to basically the budget. I think if we're talking about, like, part of this is essentially what is reasonable to be indemnified by MIABC or indemnified by the district. If there's a concern about a power discrepancy with the one person agreeing to the amount, then adding a second signature provides that financial control and eliminates that power discrepancy, which with this particular bylaw doesn't exist in a process in our procurement policy.
Thank you for that context. I will go to staff now to answer on the second question, which I've forgotten what it was, but I'll go to you.
The second question, I believe, was around conflict of interest and if a council member would be indemnified if they inadvertently have a legal claim arising from a conflict of interest scenario. Is that my understanding? Is that correct?
I believe Councillor Pettingill, does that capture your concern? You're asking about this piece around conflict. Well, let's take the answer. And we'll see if it addresses your concern. Is that okay? Okay.
Okay. The first thing I'd like to state is that the purpose of the indemnification bylaw is to protect officials, you included, that who are acting in good faith while doing their jobs. It's to prevent, and then some of the restrictions in the bylaw are to prevent the use of public money for shielding personal misconduct. So I think the key word around this is acting in good faith. And then in terms of the conflict of interest component, the limits on indemnification. So this is what the district will not cover in terms of legal claims. And conflict of interest is not included in here. And it's important to note that most of these elements, except for a couple, are directly from the legislation. So council has the discretion to be more restrictive and limit the number of things that will be covered through the indemnification bylaw. So right now, the way it's written, conflict of interest claims would likely be covered unless there's a conviction and there's a fine issued, then the district couldn't pay the fine. Council has the discretion, though, to totally eliminate covering conflict of interest claims that may arise by including that in this section. Is that clear?
I think so. So I think one of the risks that happens one of the risks that exists in these roles is someone could bring at any point in time a conflict of interest matter forward. Even if it was frivolous, I would need to go through a legal process. And I think there's a difference between having that happen and it ultimately being not coming to being dismissed or coming to some other conclusion versus, oh yeah, there was a conflict here and there's a penalty. And if there's a penalty, then our indemnification wouldn't apply. Is that correct?
That's my understanding, yes.
So that's the safety net here. And I think that's reasonable. And I think without that, sitting in these seats becomes even harder than it is, because we're open to this risk that could just, I don't know how else to. It's not appropriate, I think, to be exposed to that risk unless you did something that was ultimately found guilty for, and there's a penalty. And I think that this addresses that. I'll go to you, Councillor Pettingill, then I've got Councillor Stoner.
Yeah, maybe not a topic of discussion for tonight, but it seems to me it might make more sense for us to set aside a bit of a funds where, if you are unsure, there's some support to get that as a counselor, a clear legal advice on conflict. So you're not sort of saying, oh, maybe I can take a risk and try and do my best without a lawyer, which seems to be sort of where this is pushing us, and hopefully we'll catch it on the back end, as opposed to like actually have a very high standard and maybe less indemnification if you're offside on conflict, because you would have had the ability to check in with legal at the start before doing anything wrong. But
I think, thank you for that. I have seen some remuneration bylaws that include the ability to use some discretionary funds for a conflict of interest consult, legal consult, or something like that, up to a certain amount. So I think that's where I like that suggestion, but I think that is important, but is outside of this. Obviously, it'll interact with this. Do you have thoughts on this?
I do. So I don't have the language in front of me exactly, but the Code of Conduct bylaw does allow for counselors to seek approval from the CAO for a legal opinion if it's related to conflict of interest. So that language is written into the Code of Conduct bylaw, and the intention isn't to have all matters, if they're tangential, go for a legal opinion. But if someone is truly concerned, there is an avenue through the Code of Conduct bylaw to seek a legal opinion that is covered by the district.
Okay. Councillor Stoner, I think you're next to my speakers list.
Yeah, just trying to consider this component around conflict of interest. On the limitations list, 5.1b specifically says willfully acted contrary to the terms of their employment. And I had originally flagged that because employment is generally a difficult word for those on this side of the table because we're not technically employees. And so I wonder if it's worth adding in a bullet around like willfully acted contrary to the terms of their oath of office or in contrary to the community charter or the code of conduct to kind of capture that component. And I don't know if I'm ready to propose that today off the fly because I haven't thought through the potential negative implications thereof. But I wonder if staff have any thoughts around that, like weighing of contrary or like willfully acted contrary to the terms of their employment and how that can be reflected, or if it is already reflected in the other language there for council members who are not employees.
The number was 5.1b. I don't know.
I mean, I do think that 5.1a maybe just does it, like been guilty of dishonesty, gross negligence, malicious or willful misconduct is maybe sufficient. But that's maybe more for my council colleagues to consider if they feel like that is sufficient and strong enough, given the other avenues that we have as well with code of conduct layered in here.
Yeah, when I was reading this document, that piece felt like it didn't apply to me. It applied to the employee piece, but there's also nothing that really separates out those categories in the document itself. So is that sort of the intent there? It's not meant to cover. I know I agree with the spirit of it, but just the letter of it really seems to speak more towards employees than elected officials.
Through the mayor, I would agree that it speaks more towards employees than elected officials, and there is a differentiation there.
Okay. And I don't think that these matters are large enough or that we need two separate, like we don't need two separate versions of this to cover, like to parse that out. I think this makes good sense to me that some pieces, the wording's just not for us, the wording's for staff. Any other questions on this? I'm going to look to Councillor Hamilton. I think we might be ready for a motion that may include an amendment.
So I will move the staff recommendation that the District of Squamish indemnification bylaw be given first, second, and third readings with the addition of and CFO and Chief Financial Officer after Chief Administrative Officer in Section 3.
Okay. Are you seconding that motion? And I'd like to have a minute taker. Was that clear? Okay. Go ahead, Councillor.
Thanks very much. The indemnification bylaw, I think this is a really important piece of our municipal framework. And like so many things in my first term here on council, you didn't really reflect on how important these things are until you read it in the bylaw and think about all of the ways that things can go sideways for all kinds of various reasons. And I think it's important that we have a bylaw that helps us and supports employees and councillors in the event that there is some under the honest and under the honest carrying out of their duties happen to fall into some kind of legal dispute. And then if they are guilty of those offenses, that they are held to account. I think it's important that we have that. And I absolutely recognize it's difficult to define those things. And that's why we're here tonight. And I think this bylaw does a pretty good job of defining them as best we can. Thanks.
Thank you. Other comment? I'll go to the seconder and then I'll go around. Go ahead.
It's important that bylaws like this get regular review, and I'm happy that this one is in front of us, getting the modernization that it's being given, and a little bit of extra spice. Thank you, Councillor Hamilton, and the rest of council for the discussion to get us to the place where recognizing adding the CFO in Section 3 is a prudent thing to do. Thank you, staff, for the good work to get this in front of us.
Thank you. Councillor Stoner.
Yeah, thank you to the chair. Happy to support the motion on the floor and the updated bylaw in front of us. I think it's important to note that this is not necessarily new indemnification that we're providing to council and staff. It's an update to a bylaw that was originally written in 1998 and brings it, as Councillor French said, up to more modern standards and reflects the current wording in the Local Government Act and the Community Charter. So I think that this is just good prudence on our part to make sure that our bylaws are up to date and reflective of current practices.
Thank you for that. Councillor Pettingill.
Yeah, I think I'm going to support this. I think I'm a bit intrigued by my colleague's comment, whether or not we would limit indemnification for when there's a code of conduct or oath of office violation, those two in particular. And I guess, part of me is like, yes, if you've willfully violated those things, I don't think we should be indemnifying you. But I'm not sure there's a case where you only violated those where you would need indemnification. Like it may be a non-existent use case. And so that's why I'm not sure if that's one to push on, but I'll just sort of flag, and maybe if staff has a moment to sort of see, is this even a real thing? Because I do feel a bit uncomfortable with the idea of, I guess I'm looking for some alignment, like if you've acted contrary to the terms of your employment or your oath of office or your code of conduct, maybe makes a little more sense. I guess I'll leave it there for now, but that's the one piece I'm struggling with a little bit.
Thank you. Any other comments? Just in reply, I think the answers for me personally, the answers that I received from staff were this is really that external thing. So when it goes past a code of conduct, and I think if you violate your oath of office, it's these other processes that would determine that. So I'm comfortable with where we are. I do think that as Councillor Stoner stated, this is an update to a very old bylaw, and the legislation that it relates to has changed in that time, and this is a modernization. And I think it's important to for folks to understand that this isn't about creating a shield for elected officials that have done something that is offside, or in this case illegal. It's about ensuring that that these seats are and these roles are reasonable things that people could be expected to participate in. And I think without the reasonable protections that this provides, I would have a very hard time sitting in these seats without these protections. But again, this does not provide protections where folks have clearly gone into the clearly offside. So happy to support this, and I do think that after when this gets used, I would expect I'm happy that it sat for so long, in so much as it doesn't feel like it's been used very often. So I'd imagine that going forward, if this does get used, that it continues to be refined to ensure that it's performing its duty and not more than it's intended to, which I think is really important. With that, I'll call the question. All in favor? Motion carries unanimously. Thank you. So our next order of business is section 8A1, Land Back Task Force Terms of Reference and Appointments. So staff are just getting set up for the presentation, and we'll get underway when they're ready to do so. The floor is yours when you're ready.
Thank you very much to the chair. Good evening, council, public who are watching online and in the audience. My name is Linda Glenday. I'm the Chief Administrative Officer here at the district. I am joined by Ms. Asia Peterson, who will introduce herself in a moment. And we are presenting about the Land Back Task Force, which is a priority activity in the Memorandum of Understanding with Squamish Nation.
Hello, Mayor and Council. My name is Asia Peterson, and I'm the Projects and Research Coordinator. Privileged to be here tonight and honored to be working on the traditional unceded territory of the Squamish people. Thank you. So as Linda mentioned, we are here tonight to present on the proposed terms of reference and to seek 3 appointments to the Land Back Task Force. On March 4th, Squamish Nation Council approved the terms of reference that you'll see and appointed 3 of their own council members to join the task force as well. Next slide. Just a bit of background on this report that I'll highlight. In 2018, Council formally recognized the United Nations Declaration on the Rights of Indigenous People, otherwise known as UNDRIP. And in building on our own relationship with Squamish Nation, in 2023, Council signed the Wa'im Squamish Protocol Agreement, which led to the development and signing of the Memorandum of Understanding between the 2 governments in 2025. So this built on a long history between the partnership with Squamish Nation and was a significant step forward in our reconciliation journey. The establishment of a Land Back Task Force was identified as a priority activity in the MOU. In both the protocol agreement and the MOU, principles are outlined to help guide this work in an intentional way. So I just wanted to highlight them here before we begin. Listen and engage, follow the ways of the Squamish, genuinely care, learn the advice of the Squamish, the people go through it together, and protect the rights and title of the Squamish. So before we review the details of the terms of reference, I wanted to take a minute to highlight the concept of land back. This is an intentional term that we use. Land back is a reconciliation-driven initiative that acknowledges the impacts of colonization on Indigenous people. It aims to restore governance, stewardship, and cultural connections to land. So in this context, land back is referenced in the MOU, and it means exploring possibilities for the return or the co-management of public lands in a way that respects Squamish Nation rights and title. Land back is not a threat to private property. It's about reconciliation and moving forward together. It's not about exclusion. So in turning to the terms of reference, as I mentioned earlier, the task force will have 3 representatives from each government. Squamish Nation appointed all 3 of the Squamish Valley councillors earlier this month, Deanna Lewis, Anthony Joseph, and Johnny Williams. The terms of reference outlines that this is a time-limited task force. It will exist until 2028 or until project deliverables have been met. And the task force will meet on a quarterly basis. So now I just wanted to highlight the structure of the task force. This graphic is an overview of what the structure will look like. Staff from both organizations will provide the research, administrative, and technical support, and will develop work plans for task force approval. The task force will inform, advise, and engage the community on this work, and then all recommendations will go to both respective councils for final independent deliberation and decision-making. Next slide, please. I now wanted to highlight some of the roles and responsibilities of the task force. Really, the function of the task force is to serve as a coordinated research and engagement mechanism between the 2 governments. It's to coordinate research efforts looking into land back opportunities. So once the task force is established, they'll approve work plans and a communications and engagement plan. The task force will review and analyze the research that staff produces. They'll provide guidance on community engagement and dialogue opportunities. And then based on this research and community engagement process, the task force will make recommendations on a framework. Those recommendations would go up to each council independently for consideration and decision-making. The task force itself does not have decision-making authority. Next slide. So in terms of the scope, at this time, the scope of the task force is limited to exploring, researching, and engaging district residents and Squamish people on the topic of land back. Some of the areas that the task force could explore include the nation's historic continued connection to their traditional territory, reestablishing cultural and linguistic connections to the land, ways to enable shared decision-making or co-management of lands, potential policy updates, ways to support or advocate for Squamish Nation as it relates to Crown land, and any other initiatives that might be identified. One thing that we should emphasize is that private property is not involved with the scope of this task force. So some of the examples that the task force could consider making recommendations related to are things like co-management of parks and protected areas, restoring original place names, granting exclusive access to cultural sites for Squamish people, facilitating access to traditional harvesting sites, exploring opportunities to recommend policy updates for district land dispositions or leases. Again, these are just some examples. There'll be other opportunities that haven't been identified yet. So finally, community learning and dialogue opportunities are central to this work. We know that these topics are complex and nuanced. So as a first step, we're focused on providing community learning opportunities. We'll be providing a ton of resources on our website and leveraging our library's capacity to support residents in better understanding these topics. A comprehensive trauma-informed community engagement plan will also be shared and approved by the task force. So in returning to the recommendations for consideration, we'll leave it here. Thank you for your time, and we're happy to answer any questions you have.
Thank you very much. Council, do you have questions for our staff at this time? Councillor French.
Thanks, Mayor Herford. I think that this is a bit of a housekeeping question. With the meetings that are expected to be ahead of us, held in spaces provided by each organization, as we see in the report, I'm guessing the district space will likely be this chamber or within Municipal Hall. And I'm wondering, has the Squamish Nation indicated their space of choice? Is it Totem Hall or another location? Is there maybe an indication that the Squamish Nation would like meetings to be held in North Vancouver? Can you give us any insight into that?
Oh, sorry, thank you. Through the chair, I think since all of the appointed members from Squamish Nation are from Squamish Valley, Totem Hall would likely be the space to convene.
Thank you for that. Very practical consideration. Councillor Stoner.
Thank you to the chair, and thanks to staff for the very clear presentation and report in our package this evening. You mentioned that it's a time-limited task force to 2028 or until such time that the task force has completed its outcomes. I'm just wondering if you can speak to why 2028 was selected as kind of the end date.
Yeah, through the chair, the 2028 deadline was selected because that's where we've identified priorities in the MOU. It was from 2025 to 2028. So we put that timeline on it to align with the MOU.
Thank you. Councillor Penningill.
Yeah, just curious if you can remind us, because we've also committed to meet council to council with Squamish Nation more frequently, if we know sort of how that intersects with this, and would this task force sort of report when the broader council meetings, or does it more come to our individual sort of staff and councils and sort of separate from the broader MOU council meetings?
Thank you for the question through the chair. I would say it's both and, that there will be times when staff come to council and council needs to make their own decision in district chambers as an example, and same with Squamish Nation Council, and the opportunity for the Land Back Task Force themselves to present to both councils at the same time would likely prove fruitful.
Okay. Any other questions for staff? Councillor Stoner?
Yeah, thank you through the chair. Also appreciate the clarity on the focus here on public lands. I'm curious if there's been any dialogue amongst staff in the development of the terms of reference of inviting other orders of government in. Much of the public land that exists within the boundaries of the District of Squamish are Crown lands. And so how do we start to address this conversation, or is that a topic for the task force to do, of what that looks like?
Thank you. Through the chair, I would say it's the latter. So at this point, staff are bringing terms of reference for each council to approve. Following that, the task force themselves would commence that work.
And I think that point is very important. And in the terms of reference and the scope, the second bullet point from the bottom, I guess is the way to describe that. It's not numbered. Support or advocate for Squamish Nation as it relates to Crown land dispositions. That doesn't quite cover the totality of the interacting with the Crown more broadly, but there's definitely sort of recognition of that there. But I do think much of the terms of reference, I would expect the group jointly to look at this together and see if there's room to move. At this point, any changes to the terms of reference would need to be negotiated with the Squamish Nation. I do think the task force is the best mechanism to sort of recommend whatever those changes would be back to their own board or governance structure. I'm not seeing any further hands for questions, so I will move that council approve the terms of reference for the Land Back Task Force and appoint 3 members of council to serve on the Land Back Task Force as follows: Mayor Herford, Councillor Stoner, and Councillor Anderson. And I'll speak to it if it's seconded. Second by Councillor French. Thank you. I think this is incredibly important work. And I'm going to read directly from the terms of reference. The Land Back Task Force exists to research, learn, and engage both District of Squamish residents and Squamish people on the concept of land back. Its primary goal is to develop a framework for land back in the District of Squamish, including policy considerations for future public land dispositions by the District of Squamish and joint use of district lands. I think this is incredibly important that we have this dialogue with the Squamish Nation directly and with our community around what this is and what it isn't. We've heard a little bit in the presentation around what this isn't. It is not something that's and we do not have the entity itself. The task force does not have decision making in power in and of itself, and neither does this group have decision-making power around private land. This is not what it's about, but there are some very meaningful conversations to be had, and in a good way. And those need to be shared with the community, and that is a lot of what this is in my mind. And I've heard some fear in the community and around the province and country around this, and I really. My expectation is this can be a vehicle to fill those gaps in understanding that folks have often filled themselves with fear. So this is a really important piece of work, and I really think back to the protocol agreement where we committed to as a group in this room and as a community to listen and engage, to follow the ways of the Squamish, to genuinely care, to learn the advice of the Squamish. And I love this one. The people go through it together. We are all going through this together as a community, the residents of Squamish and the Squamish Okmeo. We're going through this together. And I think this is a together part of that, as well as protecting the rights and title of the Squamish. So I look forward to working with Squamish Nation and my colleagues on this. And thank you to everybody involved to get us to this point. I do think that having a table to sit at to discuss these matters with our neighbors at the Squamish Nation is incredibly important, and likely at any point in time, but particularly at this point in time. So I'm thankful for the creation of this initiative and look forward to doing the work. Other comments on this? Councillor French.
Thanks, Mayor Herford. This is exciting tonight. The task force has an important historical mission ahead. And coming into this meeting tonight, I've had some mixed feedback on this task force from many people. And surprisingly to me, a little bit, people from all over the province. Many eyes are on Squamish tonight with this decision and this recommendation and this motion. And what I've discovered over the last couple of days in going through the feedback that I've seen is those who get what we're up to, they truly get it. Those who don't, in my opinion, are mainly driven by fear, feelings of superiority, and a belief that there's no historical wrongs to be reconciled. I fully disagree with that. There are wrongs to be corrected, and part of what we're doing tonight is taking that on. And the path that we're continuing on with the Squamish Nation feels minimal when I think about my white European ancestors who came here, claimed these lands, and introduced the human construct that we call private property. And the newcomers to this place then tried to assimilate the Squamish people into European ways using what I think are cruel tactics, and many people agree with me on that. With no ability to undo the historical hurt brought to the people who lived here for thousands of years before my ancestors arrived, I see this task force as a small step along a path that we're meant to be on until we can all collectively agree that true reconciliation has been achieved with the Squamish people. Councillor Lewis told me a few days ago that she's stoked about the work of this task force, and she's keen to learn who's appointed to the task force to represent the District of Squamish. We've achieved that, I think, or we're about to confirm that tonight. And I want to add that transparency through this process is important to me individually. And I've heard from many in our community that transparency with this process is vital to them as well. I pledge to do all that I can to promote public education through this process and to keep the work of the task force as transparent as it possibly can. And when my time in this seat comes to an end, I expect that I will point to the work of this task force as a high point in my political experience. I support the recommended appointments, and any one of the elected officials, I believe, in this room tonight would suitably represent the District of Squamish on this task force. I'm happy that we've selected the three that we have. I support the motion in front of us.
Thank you very much, Councillor French. Councillor Stoner.
Yeah, thank you. Through the chair, happy to support this motion this evening. And I think back to even when we just signed the MOU in mid-July, the context was very different. It was before the Cowichan Tribe's decision court case came forward. And there was a real pivot in the provincial, let alone the national narrative around the path of reconciliation. I think as I continue to reflect and hear the concerns that are emerging, and I think some of them they feel like valid concerns for many folks because there's a lot of uncertainty. I actually think what this task force does and our continued commitment to reconciliation does is actually open up the opportunity for dialogue, for understanding, for education, learning, and sharing. And that is what our community does best across both Squamish residents as well as the Squamish people. As Mayor Herford reiterated, I think one of the most appropriate components of the principles of the MOU that applies here is that the people go through it together. We are all in this together and we're trying to find our way through it. I'd be lying if I said we all knew the answers, but to Councillor French's point, I think our council, our staff, our community, and I've heard this from the Squamish Nation, this task force is committed to transparency, to engagement, to research and shared learning, developing a framework that we can all feel comfortable with to move us forward on a stronger foundation, because we are all going to be here together no matter what. And we can either battle it out in court, or we can build strong working relationships and move forward together, show up represented to the province together as opposed to apart. And I think that's the piece that we're looking for in this work. And I'm honored to take it on behalf of council, of community, and with council and our staff.
Thank you for that, Councillor Sawyer. Councillor Anderson.
Thank you, Mayor Herford. It will be a great privilege and responsibility to be serving on this task force. I am looking forward to fulfill the principle that's outlined in the staff presentation tonight. One of those principles, listen and engage, and I'm going to be learning how to pronounce that in the Squamish language. But that's one that leaps out for me. We need, and it responds to community interest as well, of course. I see this, I'm looking forward to a process of exploration as well as an educational process. Councillor French has so eloquently reminded us that, or pointed out that many eyes will be on Squamish. So it will be important for a learning process, important for other communities and agencies well beyond Squamish. So this is an added responsibility that I look forward to facing. Thank you very much.
Thank you, Councillor Pettingill.
Yeah, thank you. Happy to support the motion. Just reflecting on a few things, I was never really a huge fan of the Harper government, but in 2008, that government apologized for the residential school system, and later, a couple of years later, adopted a United Nations Declaration on the Rights of Indigenous Peoples with a small caveat. But then in 2016, the Liberal government, I guess the other side of the aisle, you might say, fully endorsed it. And so, you know, colonialism and our history and how we move forward is something that Canada has been grappling with for a long time. Our democratically elected national governments from both sides of the aisle seem to support, when you sort of read the text of what they were doing and why they were doing it, it is, I think, as my colleague pointed out, understanding there's a more constructive way than battling things out in court. When we try and understand and see each other's as human beings, and trying to understand what we all need and how we can best move forward together, that's kind of the path to success. And that's what I really see is sort of the common element between these different governments and these different documents that we're all trying to work towards. And I think that applies here too. I'm really proud of our community every day on the National Day for Truth and Reconciliation. I see all the orange shirts walking down the street together. And I think this is just sort of that next step. There is a whole lot of fear, I think, born out of a whole lot of misinformation and political opportunism, which is really quite frustrating. But I think it's a fantastic opportunity to have some really great conversation that I think should make things better for everyone at the end of the day. I think this is a path of, and it is the underlying goal of how do we make this a better place for everybody. And I think that's really what this is all about. And so I know this is something that our whole council has felt passionate about, and it's pretty hard to I think we all sort of would have liked to be in the room, but even if we're not in the room, we'll be finding other ways to support these absolutely critical efforts. With that out of the way, just one small thing, I do see that the budget for this is part of our broader memorandum of understanding budget. I do sort of wonder, and maybe the task force needs to ask for this, but if there's a bit of a clear number that this task force sort of had to sort of scope, like how far they can go in terms of having these community conversations and so on, just a small thought as I read through the report. But otherwise, I'm very happy to support this, and thank you to the colleagues that will be leading this.
Thank you. Councillor Hamilton.
Yeah, thanks very much. I'm very happy to be supporting this motion. This is extraordinarily important work. And I'm extraordinarily grateful to my colleagues who are willing to take it on as members of the task force. And I'm really grateful to staff for helping get the councils to this point. I think staff play a vital and pivotal role in having our councils be able to have constructive, careful conversations, delicate and challenging conversations with each other. And so I think this task force is really a culmination of a lot of staff work to be able to have challenging and difficult conversations with each other in open and receptive ways. So thank you to my colleagues for taking this on. And I certainly look forward to hearing as the task force progresses.
Thank you very much. And thank you, Council, for all the thoughtful comments. I would love to riff on each of the themes that have emerged here. And I do think that really highlights the importance of this work. So we will. This is clearly not the last touch point for this. So we'll save my comments for the next time these matters are before us. I'll call the question. All in favor? Motion carries unanimously. Thank you very much. Thank you for all your work. So next, we don't have any late agenda items or correspondence action requested, but we do have items referred from the consent agenda. So we're on to 11 C, I think is what both of those are. So Councillor Stoner, you pulled 6D1. So this is the 5-year, the STR review. And just to orient everyone, I know Council knows this for the most part, we don't, with these pieces where we have a memo from staff come through, we don't have the staff available to answer questions. So if we have questions that are more involved, we could refer these to a future meeting to dig into them further. But just with that caveat, I will turn it over to you to get us started, Councillor Stoner.
Yeah, thank you. Through the chair, I was going to refer this to a future committee of the whole for further discussion. And if that's seconded, I'll speak to it.
I'll second it. And do you want to go ahead?
Yeah, and thanks for seconding it before I actually articulated why I would like to discuss it further. But there are some components in the report that flagged to me that I think are just worthy of some further council deliberation. In particular, is the suggestion that we continue to encourage folks to reapply for temporary use permits after their 6 years. So under the legislation, you technically can reapply for a TUP under a new application. It's not generally our practice to do so, and I think that that's worthy of some council deliberation as to whether that is practice that we want to address. And then we also got some late correspondences today from Tourism Squamish that would also amplify, I think, a further dialogue around our short-term rental regulation policy.
Thank you. Yeah, thank you for that. The broader, the TUP issue here is broader, I think, than just this use of TUP. And I think that with that in mind, just whether this is the preferred mechanism, and I get that that's likely a future action thing. That's not something that we have in our work plans, but I'd really like to have a discussion around that. And I think this is such an impactful piece for the community that it does deserve more space than, and I know it's going to take more, those sort of future action items piece make good sense, but I do think we should spend a little bit more time with this and address some of those or discuss some of those issues. I'll go to you. Did I see a hand? No, you don't have to. You can't. Councillor Pettingill, is that your hand?
Yeah, I appreciate this coming back. And just one thought, maybe for staff to think about or for us to think about when it comes back. I know there's been some question or concern about has this policy, how many units has it returned to the long-term rental market? I think that is one aspect, or in my mind, one aspect or one goal. The other piece of it, at least one other piece of it for me was, if a home can be a revenue generator, does that then raise the price and sort of force everyone to either do that or pay a very high price for a home? And so it's not just about returning units to the long-term market, but what it does to affordability. And we have many things pushing affordability in different directions. So not thinking that's, there's one magic solution here, but if there are any additional thoughts or new information about the push and pull there in terms of the affordability of a home that may be useful for our next discussion.
Thank you. Just another piece of this is the fees are meant. I'm curious to dig into the fees a little bit. The fees revenue were generated 156,800, and the annual expenses to administer the program were at 145,000. And it did say that the third-party monitoring services dropped out of that. And I want to understand that better. And if inside of that cost recovery piece, and that's pretty close to the line with the numbers that are there, just how we're distributing those fees inside of that, I think is worth some. So I'd like to dig into that little piece a little bit as well. But that is for a future meeting, which is exactly what the resolution is. So with that, I'm going to call the question. All in favor? Motion carries unanimously. Thank you. And then back to you, Councillor Stoner, item 62.
And I'm going to move receipt of this memo because I just want to speak to it and highlight it.
Is there a seconder for the motion? Councillor French. Go ahead, Councillor Stoner.
Yeah, thanks. I couldn't help myself but to pull this one because I think that there's some really great numbers in this memo, which speaks to the expansion of the Evolve e-bike share program, which we launched last summer. So in just 166 days of its first year of operation, there were across 54 bikes were deployed from 18 locations. That saw 1,318 unique riders for a total number of trips of 3,906 over those 166 days. So BCAA, who runs the Evolve program, is looking to expand to an additional, almost doubling their locations to 33 new locations, extending into Garibaldi Highlands, Oceanfront, Brackendale, and Mamquam, and providing a new opportunity for folks not just ride on e-bikes, but also on e-scooters. And I think that this is a fantastic opportunity for our community to have different forms of transportation and micro-transportation across our very spread out community.
Other comments on this? Councillor Pettingill.
Yeah, I was very happy to see this. I think it was in the first week or two after launch, which was not meant to go past the Mamquam. I saw folks at the bag with a pile of bikes because they'd ridden the bikes to the bag and then they, I guess, rode them back downtown or wherever. So having this stops available in the whole community, I think is a great thing. I'm sort of curious and really curious to see how the scooters go. I'm sort of wondering if those stay more localized. That's just a curiosity. Just a slight tangent. I saw, I think, an email that the on-demand transit service is starting to, and so there's a lot of really exciting things, and I have people asking for more already for the on-demand. So it's great to see these things moving forward.
Thank you. Any other comments on this? I'm going to say yes to those comments that I've heard already around the table. It's really remarkable success here. I think Squamish, in various initiatives, it hasn't quite been the right size to support some other initiatives around as fulsomely, like car share has a, we all know the challenges, but to see something really be such a good fit for our community is really great, and it shows when there is a fit that works for people will use it. Those 1,318 unique riders that's a lot of people. That's impressive, and that is with only 54 e-bikes in 18 locations. So I'm really looking forward to seeing and feeling how the community feels when there's far more both locations and bikes available. And one of the pieces that should jump out to everyone that reads this report, not that there may be a lineup for people to read this report, is under the budget section. I'm going to read the very first section. The partnership does not cost the district money. Remarkable. So happy to support. Of course, we have folks do need to on our team that do need to do some what have been described as sort of light touches around some planning for these, but essentially the operations of these do not cost the district money, and that's really remarkable. Oh, and a little side note that there are the bikes and the scooters both have GPS enabled, and any that go astray are found and returned to. So there has not been a lost piece. Thank you for that. I'll call the question. All in favor? Motion carries. Thank you. I think those were the two pieces left. So now we don't have any business arising from the minutes. We have no notice of motion. Open question period, clarification related to agenda items. Is there anybody in the audience this evening that has a question of clarity for council? Seeing none, council or staff announcements. Go ahead.
Thanks, Mayor Herford. I wanted to share that on Wednesday, March 4th, I attended a youth council event at Howe Sound Secondary. Some of my colleagues might want to pick up where I leave off on this. Thank you to Councillor Stoner, Pettingill, and Greenlaw for the work that you did to prepare for the night and just generally your work with Youth Council. Squamish has some very bright young people who are engaged and actively working to make Squamish more inclusive and offer a wider range of things for all young people to do. I was impressed. The future is definitely bright.
Thank you for that. I would agree with that assessment. Councillor Anderson.
Thank you. The Railway Museum of BC is hosting a Sea to Sky model train and hobby show. It's an annual affair, and I've been to a few of them already. It'll be taking place this weekend, Saturday and Sunday, March 21st and 22nd. Fun for the whole family, says the ad, and that is certainly true. Model train layouts of all scales, opportunity to climb onto the Royal Hudson or Engine Number 2 and other artifacts in the railway park. People can ride the museum's Bud Rail passenger car, be going up and down the track. Railway is topical these days, and certainly in Squamish, and railway modelers are not only enthusiasts, rail fans, they are experts with broad knowledge of the history, technology, and possibilities of railway transportation. So anybody's curiosity will be satisfied at this model train and hobby show taking place this weekend. Thank you.
Thank you for that. Go ahead, Councillor Pettingill.
Yeah, two things. One, we have an endocrinologist now in town regularly. So as a diabetic, I always had to do my calls remotely, or sometimes they come to the drop-in center. I think I was the first patient on their first day. So it is an endocrinologist that is typically in the city, but they have an office here now. And so for anyone struggling with diabetes and so on, I think it's sort of, I know there's a lot of challenges that come with growth, but seeing more services like this, I think make the community a lot better. So that was great to see. And then I also just wanted to had an opportunity with my partner to go to the fashion show at Howe Sound. It was a fundraiser for prom, and a really great show. It hurt a little bit to hear some of the giggles and laughs at some of the outfits that, I think we wore and we thought were cool, but it was a really great event. So thank you to everyone who put that on.
You have to submit some photos to document this. Councillor Stoner.
Yeah, thanks through the chair. I'm going to look forward a little bit. Later this week, we will be welcoming a delegation of local government officials from Zambia here in Squamish as part of the Partnership in Municipal Innovation Women in Local Leadership program that we've been involved with through the Federation of Canadian Municipalities and Global Affairs Canada. I'm actually not sure how many folks will be welcoming from Zambia, but there'll be a group of folks who have traveled this way. And the PMI Will project is really focused on achieving gender parity in local councils and ensuring inclusive approaches to service delivery in all the work that we do. And so we have been partnered with the Local Government Association of Zambia, and we've had the opportunity for myself and some staff members to go down and work with the folks on the ground in Zambia. And this is a chance for them to come here and share some of the learnings in both directions. So really excited to welcome them. And then also another component for Youth Council to flag and mark on your calendars at the end of April. Squamish Youth Council will be putting on a one-day event called Rise. which the description says the Rise Youth Summit is an in-person event where young people come together to share ideas, learn new skills, and ignite their passion for making a difference. Expect awesome speakers, interactive workshops, and tons of opportunities to network with peers who are just as driven as you are. And there's currently a call out for speakers, either keynote speakers or folks who might want to deliver some workshops at this event. And they are looking for folks who have skills or experiences to share that fit the areas of health and wellness, real life skills such as budgeting, cooking, mending, navigating taxes, leases, and other adulting basics, as well as business and career basics. So if anybody has any ideas on who would be a great speaker for Youth Council and their youth summit, who would like to share some tips and tricks on how to be an effective adult, I could sit in on a few of those. But there's an application form, so I'm happy to share that with council if you feel like you would like to pass it on to someone. Thanks.
Okay, any other comments? Also attended the Youth Council event and making the case for local businesses to, I would say, cater to youth and the benefits of doing that, including suggestions around hours of operation and so on. It was great to sort of see them really articulating what they'd like to see and being brave to really ask for it directly from the business community. So it was great. And I'd like to thank both the youth council members for their continued work and advocating for the things they'd like to see in the community, and to our business community for responding. It was really remarkable. We know that just running a business is very demanding, and it's very challenging times to be in business. And there was a big chunk of the business community that came out to be part of the event, and I think that's a great response to the youth in the community asking for that. So, and we've already heard some foreshadowing of what's coming ahead with Youth Council. So I look forward to seeing that. Since we were last here, I had opportunity to. We have I'm going to use air quotes, a monthly meeting with the mayors and chairs in the Sea to Sky corridor that seems to happen every couple months with everyone's schedule. Was this the week before last? We got together in Whistler we had Mike Richmond, Mayor of Pemberton, Jack Crompton, Mayor of Whistler, myself. We had Patrick Weiler joined us for the conversation, and he brought with him Gregor Robertson, who is go through his portfolio here, is the Minister of Housing and Infrastructure and Minister responsible for Pacific Economic Development Canada. So when I think about the needs and concerns of Sea to Sky, he's a critical player here, and it was great to very thankful for our MP, Patrick Weiler, who does, this is one of many examples of him bringing folks together and bringing the important ministers from his government to community. And Mr. Robinson was very engaged and very knowledgeable about the moving pieces, down to like a surprising level of detail happening in the Sea to Sky. So many of the concerns that we have a lot of things that are in our direct control in this room, but a lot of things the community comes to us for require this this advocacy piece, and it's hard to sort of highlight those places and times it's happening outside of direct letters and so on. But this is a great opportunity, and I think we also showed a great unity in the Sea to Sky around what the concerns are. So thankful for that opportunity, and for Minister Robertson's time. And so of course the devil's in the detail. Well, I didn't leave there with a giant check or any of those matters resolved, but we are on the and will continue to be on the federal radar. I last week I spent a few days with my elected official colleagues at the Local Government Leadership Academy, which is an important initiative supported by the province to really make us be effective in these roles, or aspires to at any rate. And it was great I always enjoy spending time with my colleagues from around the province. There was a lot of, given where we are in the term, there was a lot of reflection, and I was really struck by how open everyone was to share their, the strikes and gutters of this work, and lessons learned, and so on. So excellent opportunity, and just again, I'd like to really thank everyone that was involved. There was also, I think, a highlight for us, maybe locally, would be there was a presentation from the SLRD. So Chair Ford was there, our CAO was there, and there was also one of the staff members working on the guidebook to reconciliation was the topic, and it was great to share that with folks from around the province. Yeah, it was quite surreal to sort of be sitting in the audience as someone that sits at the table that was there, and just listening to the discussion. And the context is just so varied for this work around the province. We've had some discussion on this topic already in this room today, and it's different everywhere you go. So I thought, yeah, that was a great session, and it was good to see that work sort of highlighted in that way. I could go on, but I am very excited about the Zambia delegation this week, and look forward to spending some time with them. And I enjoy showing off our community, and the more time I spend in this role, I enjoy showing folks from around the world in local government, not just the beautiful bits that you show your friend when they come to your community. You're like, oh, we also have this and this. Like, this is the totality of it, and also where our challenges are. So look forward to having those honest conversations going forward. And I see no other hands for this piece. So we don't have a motion to close. We don't have any in-camera announcements. So I'll be looking for, yes, Councillor Stoner, can I help you?
I would move that the meeting be terminated.
Councillor French, I believe you're seconding that. I think I always feel funny calling the question even on this one. I think we'd all like to terminate the meeting. So all in favor, motion carries. Now, Council, if you were keeping score, we're actually not done our work today. We did not make it through the totality of our closed meeting that we had scheduled to conclude prior to this meeting. So we'll reconvene that meeting in 15 minutes. We'll reconvene our special closed meeting. So stretch your legs, but you're not done yet.